Convicted on corruption charges. They remain out of jail pending appeal, and this week that appeal goes to the Supreme Court with arguments tomorrow. Here to remind us of what's at stake is Randall Eliason. He is former chief of the Public Corruption and Government Fraud Section at the D.C. U.S. Attorney's Office. He now teaches white-collar criminal law at George Washington University Law School. You can read his blog on white-collar crime at rdeliason.com. Randall Eliason, thank you for joining us. Good to see you.
Great to be here. Thank you.
Can you remind us both of what the charges against the McDonnells were and what the original decision in the case was?
Yes. So businessman Johnny Williams, over a period of about 2 years, gave the McDonnells a series of secret gifts that ended up totaling about $175,000. They included a Rolex watch. He bought some $10,000 or more in designer gowns for Mrs. McDonnell, paid for the caterer at their daughter's wedding, and gave them $120,000 in no interest, no paperwork, quote-unquote loans. The government charged that in exchange for that, the McDonnells agreed that they would use the power of the governor's office to promote a product that Williams' company made called Anatablock, sort of a dietary supplement, that they'd try to promote that within the Virginia government, get Virginia universities to research it, things like that. And so that was so the basic charges were corruption, bribery, that in exchange for these gifts, the McDonnells agreed to promote Williams' product within the government. That went to a jury, and in September of 2014, after a trial, they were both convicted on multiple counts of corruption, bribery, essentially, bribery and conspiracy. And that was affirmed by the Fourth Circuit Court of Appeals unanimously, and now it's before the U.S. Supreme Court tomorrow.
As the case heads to the High Court, what should we know about the underpinnings of the existing law that the conviction came under?
Well, the principal issue on the appeal, and what the governor is arguing, is what kind of action by the government official will qualify in a bribery case. What does the government have to show that the official did or agreed to do in exchange for any gifts that he received? And so his primary argument all along, from even before the trial, is that whatever I did for Williams in exchange for these gifts, legally it doesn't amount to official acts or official action as that's defined in federal bribery law. And so it can't form the basis of a bribery charge. It might be unseemly or embarrassing or any number of things, but it's not a criminal bribery case because what I did for him doesn't amount to official action. And that's the issue that the Supreme Court has taken up tomorrow.
If you'd like to join the conversation, give us a call at 800-433-8850. Were you surprised that the Supreme Court agreed to hear Bob McDonnell's appeal? Do you think the Supreme Court will decide for or against the former governor? 800-433-8850. You can go to our website, kojoshow.org, join the conversation there, or shoot us an email to kojo@wamu.org or a tweet at Kojo Show. McDonnell's attorneys make the case that despite any appearances to the contrary, Johnny Williams didn't get any favors in exchange for his gifts and loans to the governor. You argue, though, that action is not the point in a case like the one against McDonnell. It's the agreement that's the problem. What do you mean by that?
Yeah, that's correct. So they do make a big point of the fact that Williams never got anything. He never got any of these government studies or the other things that he was seeking. But the law of bribery is very clear that doesn't matter, because what the crime is the corrupt agreement by the public official to sell his or her office in exchange for these things of value. So, for example, even if it becomes impossible, if I take a bribe to give you a contract to renovate a public building and then that building burns down tomorrow, and so you never get the chance to do it and I never do anything, that's not a defense to bribery. I still took the bribe. I still made the deal to sell my official office. So the key really is not what McDonnell actually did, but what he agreed to do, what the understanding was between Williams and McDonnell that the McDonnells would do in exchange for these gifts, and that's a question for the jury. Was there this corrupt agreement or not between them? And the jury found that there was.
What was the basis of the evidence that the jury used to decide that there was an agreement?
Well, the principal evidence was the testimony of Johnny Williams. He was the government's star witness at the trial. He was granted immunity, which was somewhat controversial, and testified for the government that he and McDonnell had this understanding. And McDonnell, of course, testified and denied it, and that sets up a classic jury question, credibility, whom do you believe? But the other evidence that supported it was the nature of the gifts themselves. These were not campaign contributions or donations to McDonnell's PAC or anything like that. These were secret gifts that nobody knew about, and extravagant personal gifts to McDonnell, not political contributions. And so the nature of the gifts themselves is also substantial evidence of corrupt intent. And it's not like they're lifetime friends or something. They had really no relationship before McDonnell became governor. So the jury was entitled to infer, the courts found, that McDonnell knew that these gifts weren't being given to him just out of admiration, that Williams wanted something in return, and that was their understanding.
Our guest is Randall Eliason. He is the former chief of the Public Corruption and Government Fraud Section at the U.S. Attorney's Office in the District of Columbia. He now teaches white-collar criminal law at George Washington University Law School. You're firmly in the camp saying that this conviction should be upheld, but what's the argument the other side is making for tossing it out? What's the harm as they see it?
The harm as they see it is that the standards are too vague concerning what constitutes an official act and when exactly the public official can be held responsible for anything they do in response to a donation or support from a contributor. So their concern is really one of vagueness and overbreadth. That this gives too much power to the prosecutors to decide who to go after, and doesn't give an official enough notice about what's prohibited and what isn't. My disagreement with that is that in a case like this, where the gifts themselves are so clearly corrupt, and it's not a case of campaign donations or routine political support, which is what McDonnell and his supporters like to talk about a lot. In this case, it seems to me a relatively straightforward example of corruption, given the nature of the gifts and then the agreement and the subsequent actions that were done in exchange.
There's a piece in the Washington Post today about the case of the former governor of Alabama, whose name is Siegelman. And in his case, the donation that he got, he was also convicted of corruption. He gave an Alabama healthcare executive, Richard Scrushy, a new term on an important industry regulatory board. But Scrushy's offering, quoting from the Washington Post, was a $500,000 campaign contribution to push a referendum measure for a lottery that would benefit the state's underfunded school system. What's the difference between that and the personal gifts that the McDonnells accepted?
Yeah, I did see that article, and these cases are very fact-specific always. It depends on the nature of the gifts and the actions that were taken in exchange. But there is a distinction between sort of legal political support, whether it's a PAC contribution or a campaign contribution or something else, and a secret corrupt gift. One difference being that donations are disclosed, right? We have campaign finance laws, we have disclosure laws, and so there's at least sunshine there, and the public can see where a candidate's support is coming from. Not true in the gifts like those that McDonnell received. And the second is the critical requirement is that there be the quid pro quo, the corrupt agreement in exchange. It's not criminal to accept a campaign donation or a PAC donation and later on take some action that the donor favored. I mean, that happens all the time. And politicians are entitled to receive political support, and donors are entitled to support the politicians that they favor. What's corrupt and illegal is to make an express deal, where you say, if you give me this, whether it's a campaign contribution or a secret gift, but specifically, if you give me this, I will do X in return. And it's that direct agreement that is the quid pro quo bribery that's prohibited.
Because I can hear a lot of people saying, well, people make campaign contributions, especially large campaign contributions, to get access, and that is precisely what they get. And that in this case, what Johnny Williams got was access. But what you're saying is that the difference in this case was that there was a specific agreement made for access. It wasn't just general access.
Yes, and a specific agreement that I will use the power of my office to benefit you in exchange for this agreement, as opposed to generalized political support and donations, which is legal and not corrupt.
I guess you have answered this question that Brian sent us by way of a tweet, but I'll ask it anyway. Would your guest's analysis change if instead of the gifts personally benefiting McDonnell, the gift was a campaign contribution?
Yes, that's a different case. I think the campaign contributions that are legal and within the limits that are set, the legal limits for